Welcome everyone to this Privacy Rules Privacy Espresso episode. My name is Alessandro Di Mattia, director at Privacy Rules, and today with me I have Stephan Mulders from Diepen van der Kroef Advocaten. I tried to pronounce it as best as possible. Stephan, sorry for that. But thanks a lot for being with us from the Netherlands, because today we are going to speak about a topic that is related to your country and is very interesting because the DPA there has released some guidelines related to data scraping. And this is a very interesting topic, in particular for what concerns machine learning and AI. And as you are an expert in the sector, I'm very pleased to have you with us in order to speak about this. First of all, I could understand from the DPA guidelines, data scraping is not allowed, in particular because there is a difficulty in identifying a legitimate interest under the commercial perspective to do so. So there is a lack of legal basis. That's my understanding. But can you, explain us a bit more about this and the position of the DPA?
Well, Alessandro, thank you. First of all, thank you for having me here. It's always a pleasure to be in your podcast. And your pronunciation is perfect. I mean, you could be a Dutch guy. What the DPA actually said is, it said, well, if you want to do data scraping, and they say well, data scraping is mostly used for AI learning, but also for web crawling, like search engines. So they take a real broad approach. But if you want to use this, you need a legitimate, according to Article 6 GDPR. And what they are saying is, well, most likely you will rely on the ground of legitimate interest, because you cannot ask permission, consent, and there's no contract. So you will rely on legitimate interest. And they say, well, according to the DPA, a purely commercial interest is no legitimate interest. And this goes a bit back, because this is a long-standing argument of the Dutch DPA. They say, well, we believe that only interests that are explicitly protected by EU law are legitimate. And they say, well, commercial interests, they are just not legitimate. This is a controversial standpoint. A Dutch court actually rejected this argument one time. There are now prejudicial questions pending at the Court of Justice. So, but the DPA acknowledges this, but they say, well, as long as there's no decision from the Court of Justice, we keep at our standpoint, and we say, well, purely commercial interest cannot be legitimate interest. Well, it's a bit of strange, because commercial interests are also protected by Article 16 of the Charter of Fundamental Rights. So even if you say, well, only positive, like explicitly protected rights can be legitimate, then it is protected. So the Dutch DPA takes a bit of a different approach than like the Belgium and the French DPAs, because the Dutch DPA say, well, if you want to do data scraping to train AI, then you need to look, well, what is the purpose of the AI model? Well, the Belgium and the French DPA, they're saying, well, if you want to scrape data for training AI, then your purpose is training AI, and doesn't matter what you use the AI model for in the end. So they take a bit of a different approach. The French and the Belgium DPAs, they disconnect the two, so the training and the use of the AI. The Dutch DPA says, well, I just take, you have to look at the broader picture. We don't know what approach will eventually prevail, but it's just an example of the differentiation of the different authorities. And the second reason why the DPA, so they say, well, commercial interest cannot be a legitimate interest. So that means that a lot of AI scraping is not possible, it's not allowed, because most is done for commercial interest. They say, well, there's small exceptions. For instance, if you want to improve your security, that can be a good reason. But they also say, well, you also need to balance the interest, and scraping just is a massive impact, has a massive impact on the privacy of the data subject. So it's likely that you will not meet the balancing test. I'm skeptical about the last standpoint because, well, data scraping is as old as the internet almost. Search engines have been scraping for years now, and although there obviously can be an impact on privacy and data protection of the data subjects, I believe that these can be managed with proper mitigation measures. So you need to think about this, but I don't believe that the balancing test will always fall on the side of the data subject.
Got it. That's perfectly clear, and thanks a lot for the overview and also your expert point of view on this, which is very interesting. I have one more question in this. We have been speaking about the legitimate interest and the various ways in which even different DPA are approaching to it. What about sensitive data? Because it's a more specific category, as we know, and might raise even higher complexities. So do you think that sensitive data might be a problem for AI scraping?
Well, the DPA certainly thinks so because they pay quite a lot of attention to that in their guidelines. They say, well, it's likely that your data set will contain sensitive data, and that will pose a problem because Article 9 of the GDPR, well, forbids the processing of sensitive data unless one of the exceptions applies. And the problem here is that, well, none of these exceptions are actually fitted for data scraping. If you think about it, well, you can't ask permission of everyone, and the exception that the data is made manifestly public also not always applies, because it can happen that other people publish sensitive data about you. So, and this exception only applies if the data subject manifestly publicized sensitive data. So they say, well, this exception doesn't apply. And there's also another problem, not explicitly mentioned by the DPA, but the Court of Justice applies a contamination theory from the Meta case last year, in June last year. They say, well, if your data set contains only a little bit personal data or sensitive data, then you should treat it as sensitive as a whole. So your data set will easily be contaminated with sensitive data if you scrape everything from the internet. Well, I believe if you think about it, this is a problem. Under Article 9, if you read it very strictly, none of these exceptions really apply. But I believe also that there is a solution, or there are three possible solutions for this. One would be that the Court of Justice makes an exception. They did for search engines. They say, well, search engines fulfill such an important role in society that you cannot ask from them to remove all sensitive data. They just cannot do it. And if you ask it from them, you need to ban all search engines. So they say, well, we don't want it, and data processing is in the end to benefit society. So we make an exception. So that's one possibility. The DPA actually says, well, it's possible that it Court of Justice will do it in the future, but not certain. Another solution for this could be that we say, well, could be the regulatory sandboxes that will feature in the AI Act. Well, it will take a while before the AI Act comes into force, but then you could use such a regulatory sandbox to say, well, we'll train the AI model in the sandbox, and then we throw away the data and just use the AI without any personal data. So that's the second solution here. And the third solution is actually in a recent conclusion from Advocate General in the case Lindenbaum, just 2 months ago, I guess. And Mr. Lindenbaum, he says, well, in order for data to be sensitive, you need to be able to draw conclusions on someone's health, sex, religion, things like that. But he says these conclusions need to be with a reasonable level of certainty. So this Lindenbaum case is about about a pharmacy. And the question is, an online pharmacy. The question is, are they processing sensitive data? And this Lindenbaum says, well, for prescription drugs, It is, but non-prescription drugs like aspirin or just the things you buy, not. He says, well, because everyone buys aspirin just to have it in house. It doesn't say that you're ill or that you have a headache. Just you want to have it because you have it, because you need it at another time. So he says, well, even if you would buy it, you cannot say that someone is ill. So I believe that if this doctrine is followed, there will be a lot less sensitive data than we think. So that might be a third way to mitigate this this problem.
First of all, thank you because you provided some solutions. and the interesting thing in this case is that the solution are not requiring an active engagement on the private side, but looking at what is going to happen at the regulatory side in particular. So that's very interesting. Of course, we have to see what's going to happen and which are going to be the position on those various points that you have been sharing with us. But that's very interesting because we know where to go and where to read. I have just one last question. We have been speaking generally about this very interesting topic, but practically for what concerns the guidelines made by your authority, which are the implications for companies that comes from those scraping guidelines?
Well, just first of all, we do not know, and I'm personally skeptical whether this will hold in court. I mean, the Dutch DPA has gotten pushback from Dutch courts and also from other courts in the past. They are known to take quite strong standpoints here that might be a bit far-fetched. The theory about purely commercial interest cannot be a legitimate interest is at least in the Netherlands, quite controversial and not followed by other DPAs. Because, well, if you think about it, every company has a purely commercial interest. That's the reason why you are working in a company. So most data processing would be illegal. So that's one thing. But in the meantime, you're faced with a lot of uncertainty. And that is a problem also because the Dutch DPA takes this standpoint, the Belgian DPA takes another far more lenient standpoint, and the French DPA as well. And if you're based in the EU, it isn't a problem because then you have a one-stop shop principle. You can just say, well, I will go to Belgium instead of the Netherlands. If you're not based in the EU and you're scraping EU customer data or data from EU residents, then you might fall under the GDPR and cannot apply to the one-stop shop mechanism. So that's a problem. And I hope that the European Data Protection Board will eventually just make one big guideline on this subject, because that will solve the problem of different authorities just trying to make up their mind and diversifying the EU data protection landscape. So I hope that this will happen in the end, but in the meantime, it will add up to uncertainty for a lot of companies. What I advise to organizations that you really document and think about, okay, I'm going to do data scraping for AI or for other purposes. Just document why you do this, why you believe that you have a legitimate interest, and what the risks are, and what measures you take to mitigate it. Because if you properly document it, even if you get in a fight with the authorities, then you will have a story to tell, and it makes much easier to explain your choices. And in the end, well, I want to end with a positive note or a negative note, depends on your standpoint. The Dutch DPA is underfunded, so enforcement is fortunately or unfortunately, depends on your standpoint, rare.
Yeah, those are all good points, and thanks a lot for moving from the general to the specific practical perspective in this answer in particular. It was clear also from the second point we touched together that there is still a need from the higher level to have a ruling on this topic before finding a solution. The topic is of course big. AI is one of the most relevant of the moment. So for sure, we expect authorities and organizations like ADPB to move on and support the private practice in doing things properly. Till then, as you say, let's be very attentive to what's happening around and have a risk-based approach, as you were saying. So thanks a lot for indicating us how to move forward in these very difficult times. It was a pleasure being with you today, Stephan. And yes, I look forward to our next episode.